century. Why are you and other human rights activists so worried about these new laws?
Well, Rajdeep, if the British laws were colonial and draconian, I want to show you very quickly how the laws enacted by this government are 10 times more draconian. First, in British period, you could keep a person in police custody for a maximum of 15 days. This limitation was put because torture takes place in police custody. Now that 15 days has been extended to 90 days and more. That's a shocking provision enabling police torture. Third, the UAPA, Unlawful Activities Prevention Act, the terrorism statute provisions have been incorporated in the new law in toto. But two important safety provisions have been ignored, removed. First is the provision of sanction. Under UAPA, if you go under the terrorism statutes, under UAPA, after the police gather all the information and make the charge sheet, that charge sheet will not be filed until sanction is obtained by government, from government. In this law now, that very important precaution that sanction should be obtained has been removed. The second safety clause, which is the authority. In the UAPA Act, the terrorism statute, an independent authority looks at all the evidence gathered by the police and then after x-raying the evidence will decide whether the police should be allowed to file a terrorism charge sheet. This second safety clause, which the Hambaram introduced in Parliament, is now deleted. Next is FIR. I heard you speak on the FIR. The FIR is to be filed immediately on a citizen making a complaint of a cognizable offence. That is the 5-judge bench decision in Lalita Kumari's case. This was done because people go with complaints, very serious complaints, and the police do not register complaints saying that we have to do a preliminary inquiry. Now, Lalita Kumari said nothing doing. If you get a complaint, register it immediately. You don't do the preliminary inquiry till after you register the complaint. Now, in the new law, they go back contrary to the 5-judge bench decision and say the FIR will only be registered after the preliminary inquiry. Now look at the DK Basu guidelines. These were issued to make sure that when a person is arrested, he is not submitted to torture. All these 6 guidelines deleted. First, the identity of the police officer carrying out the interrogation was to be entered in a register, deleted. The place and time of arrest was to be put in an arrest memo and signed by the arrestee, so that later on you can't say that this is not the place, this is not the time. Why was this introduced? Because the police would arrest and show the arrest, then 1 week later, after the person has been thoroughly tortured, deleted. The injury report, where you're supposed to be taken to the hospital to make sure that torture has not been done, has to be signed by the arrestee, deleted. The medical examination to be done every 24 hours, so that if any torture is done after arrest, that torture will show up in the medical report, deleted. The memo of arrest and the health report showing injuries is to be sent to the magistrate within 24 hours, deleted. These guidelines are to be shown at police stations, deleted. Now I take you to the statements of the police, statements given to the police. Now these statements were never signed. Even in the British period, these statements were never signed because the police could force people to sign certain statements. And now what do you have? Videography. And videography is very tricky because you can tie a man's hands and legs to a chair and the videography will be from the neck upwards and all that testimony will be taken as admissible in evidence. Legal aid from the point of arrest, not just when the matter comes to court. Legal aid from the point of arrest, riot victims, legal aid, all this gone. And you will only
Effectively-
get legal aid at the time when the
Effectively,
matter
what you're
comes to
saying,
court.